Hello friends, welcome to Tarun IAS. Today we will be discussing editorial from The Hindu of 8th of December 2022. So I have taken this editorial from The Hindu, as I have already said, from text and context. The editorial is related with the appointment of judges, the impasse over the appointment of judges. Impasse means basically a sort of a dead end, like a hurdle. So we will see what the impasse is about and what is the context of this title. You can relate it with your general studies paper 2, that is judiciary, the appointment of judges, and NJAC 99th constitutional amendment. So this is the article from the Hindu, right? Now what is the story so far? This is our Vice President Jagdeep Dhankar. He had commented on the ongoing heated debate between the central government and the Supreme Court over the appointment of the judges. So what happened? Basically, the Vice President of India, he had questioned, and by referring to the 2015 verdict of the Supreme Court, which has struck down the NJAC, that is National Judicial Appointment Commission, and he had asked that how judiciary could have run down a unanimously passed constitutional provision which reflected the will of the people. Right. So an act was passed down, and because the judiciary has the right to not exactly right, but it is under the purview of the judiciary for the judicial review of the acts. So basically, using the judicial review, or while reviewing the act judicially, it had struck down the NJAC, or the 99th amendment of the constitution of the year 2015, and in 2014, and in 15 it had struck it down. So Vice President, he had commented on this ongoing tussle between the central government and the Supreme Court over the appointment of the judges. Now what is this NJAC? Basically, the Parliament of India in August 2014 had passed the 99th Amendment Act along with the National Judicial Appointment Commission. So together they provided for creation of a commission that would have been if created, or if it had been established, for the appointment of the judges of the Supreme Court and the High Courts. The commission basically was to replace the collegium system. So we would see what this collegium system is, right? So Indian judicial appointments are done with the help of the collegium system. If we look at the Constitution of India, then basically there are no explicit provision with respect to the appointment, transfer, and removal of the judges. So collegium system, as per the Article 124 and 217 of the Constitution that deals with the appointment of the judges, it only states. Now I am going to read Article 124, which states that every judge of the Supreme Court shall be appointed by the President after consultation with the judges of the Supreme Court and the High Court. So this is what the language of the Constitution is. The keywords that needs to be focused upon is that every judge appointed by the President after consultation. So this word consultation became a sort of a problem, or it became a confusing word. That consultation with what? The Chief Justice of India? Would it be mandated on the President? Or if there is a consultation, that would it be reflecting the plurality of the views? So therefore collegium system, it evolved over a period of time. It is not an established system as per the Constitution. Rather, it is the system which has evolved over a period of time after the 3 judges case. So we would be discussing what this 3 judges case is and how the collegium system functions. But as for now, we should know that the NJAC was struck down, and what this NJAC was, we have already understood that basically it was going to be a commission that would overlook, or that would oversee, the appointment of the judges. Now, collegium system itself does not figure in the Constitution. Rather, it is referred to judges case. It is referred to in judges case. So let us see. So there is a difference. This slide or this picture shows the difference between the NJAC and the collegium system. The collegium system, basically it is based on the 3 judges case. We would discuss it subsequently. And under this, the appointment of judges, they are made by the Chief Justice of India, with 4 senior most judges of the Supreme Court, right? Is that clear? Now they are going to give names for the appointment of the judges, which will then be handed over to the president, and finally the president is going to pass an order for their appointment. So this is how it is done. This is how it is done. So if we look at the way the collegium system functions, then let's say this is the collegium, this is the collegium. All right, now this collegium, it selects some judges on different parameters. What are those parameters? They are not clear, but Chief Justice of India, for example, is based on the seniority. However, this convention has been broken in 1970s. We know that when Justice A.N. Ray was, he was made the Chief Justice of India, superseding many of the two of the Supreme Court senior most judges. So this convention, of course, has been broken in the past. And it is not a hard and fast rule that only the senior most judge will be appointed as the Chief Justice of India. However, this is the convention that is being followed in India. So collegium system selects some name and gives it over to the Ministry of Law. Ministry of Law. Ministry of Law, through various process, it scrutinizes those names. And with the help of the Intelligence Bureau, that is IB, it scrutinizes the background of the judges with respect to various parameters that it may have, and then it again sends back these names to the collegium system, which then passes it over to the president for the appointment. So president then passes an order for the appointment of the judges. So this is how the collegium system functions. Right, it has no constitutional backing, only the Article 144 talks about it, and it has evolved over the period of time. So critics says that it is basically a closed door system which lacks transparency. There is no rule parameters which would decide the efficacy or efficiency or the suitability of the judge who is going to be appointed as a judge in the Supreme Court or High Court, as the case may be. So now let us see what is this NJAC. See, NJAC is basically a body which is created to end this 2-decade-old Supreme Court collegium system. It was passed by the Lok Sabha in the year 2014, and it consisted of 6 people, which is Chief Justice of India, the 2 senior most Supreme Court judges, the law minister, and the 2 eminent persons. So there were 6 people who were going to decide that who shall be appointed to the Supreme Court as the judge or the High Court as the judge. So critics says that NJAC it needed support of others to push a name through. They fear so the fear with NJAC was the executive interference in the appointment of the judges, and it was a violation of Article 50 of the DPSP, that is the state shall endeavor to create a separation between the executive and the judiciary, and it was basically a threat to it was considered by the judiciary as an interference of the executive and a threat to the independence, functioning and working of the justice system in India. So let us see now the 3 judges case. So the first judge case was in the year 1981. It basically declared the primacy of the view of the Chief Justice of India, whose recommendations of the judicial appointment and transfer can be refused for the congent reasons. Congent means for important reasons it could be refused. So ruling gave the executive the primacy. Right. So basically in first judge case, executive was given the primacy for the next 12 years. However, in the second judge case of 1993, the Supreme Court in collegium introduced holding that the word concentration really means the concurrence. So executive via president does not have the primacy over the view of the Chief Justice of India or the judiciary at large. It is basically the concurrence. That means there will be a concurrent decision making, and it added that it was not the CJI's individual opinion, but it is along with the 2 senior most judges in the Supreme Court. So in the second judge case, there is a formation of collegium with 3 members, including CJI as the head of the collegium. Right. However, in the third judge case in the year 1998, you would find that the collegium was expanded and the plurality of the views plurality of the views was introduced, that collegium, it was expanded to 5-member body, which would be comprising of CGI and 4 senior most colleagues. So SC collegium is headed by the CGI and comprises of 4 other senior most judges of the court. The High Court collegium is led by its Chief Justice and 4 other senior most judges of that court. Now let us see what this NJAC system is. Now NJAC system, as we discussed, it was basically to replace the system that has received criticism for its lack of transparency, and among other provisions were the Constitution Amendment Act that introduced 3 primary articles. The first one was the Article 124A, which created the NJAC, which was to be a constitutional body replacing the collegium system. So one thing that is to be noted is NJAC was supposed to be a constitutional body because of the 99th Amendment Act. It also introduced another article, that is 124B, which conferred the NJAC with the power to make appointments to the court. Article 124C, which accorded express authority to Parliament to make laws regulating the manner of the NJAC's functioning. Right, so it introduced 3 articles, 124A, B and C, with different provisions. Right, so this is what was done by the 99th Constitutional Amendment Act. Now let's move on further. So far I hope the collegium system, the NJAC system has been clear, and how the judicial appointments are made. So far I am hopeful that this is clear. Now let us further move on. Now under this NJAC Act, the Chief Justice of India and the Chief Justices of the High Court, they were to be recommended by the NJAC on seniority. While now one thing is to be noted here, the Chief Justice of India and the Chief Justices of the High Court were supposed to be based on the seniority. However, the Supreme Court judge and the High Court judges were to be recommended on the basis of their ability, merit and other criteria which were to be specified in the regulations of the NJAC. So these are 2 different criteria we've understood. Okay. Now this act empowered any 2 member of the NJAC to veto a recommendation. So this is another important point that is to be noted, that veto power was given to the 2 members of the NJAC. If they did not agree with it, they can veto the recommendation. So in the collegium system, the senior most judges, they make appointments to the higher judiciary, and this was the method that was decided for the NJAC. However, we all know that NJAC was challenged, and Supreme Court and the judiciary of India, it had struck down it, considering that it is an exclusive interference of the executive in the independence functioning of the judiciary. So in early 2014, the Supreme Court Advocates on Record Association, it filed a plea which challenged the provisions which had by then become laws. So we've understood the 3 provisions that were included by the 99th Amendment Act of the year 2014 to replace the collegium system. It was challenged by the Supreme Court Advocates on Record Association. Now what was contended in the petition, that both the acts, they were unconstitutional and they were invalid. It was argued that the 99th Amendment Act, basically which provides for the creation of the NJAC, it is taking away the primacy of the collective opinion of the Chief Justice of India and the 2 senior most judges of the Supreme Court of India, as the collective recommendation can be vetoed by the majority of the non-judge members. So this is what was contended in the petition as unconstitutional and invalid. It also invoked that in the second judge case, the CGI was given the primacy and this needs the protection. It also stated that the amendment had severely damaged the basic structure of the Constitution. Now let us understand a little bit about the basic structure, and then we will move on with our NJAC. So what is this basic structure? See, basic structure so far has not been defined, or it has not been explained in Constitution. However, Supreme Court time and again in several cases have defined the basic structure of the Indian Constitution. separation of executive and judiciary is, or separation of judiciary from the executive power is one of the basic structure. The basic structure doctrine evolved in India in the 1973 Keshwananda Bharati case. Is that clear? So the second judge case of 1993, it had emphasized over the role of the CGI in recommending the appointment of the judges. And this was challenged in the petition that the 99th Amendment Act of the year 2014 is basically unconstitutional because it is taking away the primacy of the CGI. The role of the CGI is primal in nature, and because this being a topic within the judicial family, the executive cannot have an equal say in this matter. This is what the verdict had reasoned. So basic structure doctrine meanwhile refers to the idea that the constitution cannot be amended or read in a manner that would destroy its basic structure. Basic structure is basically the vision or the philosophy of the constitution on which it is based. Right? So, what were the arguments between the center and the Supreme Court? So, the former Attorney General Mukul Rohatgi, representing the Union government, it had argued that the court in the second judge case had invoked that was invoked by the petitioner was not valid in the case of the NJAC, as the very basis of the ruling was gone now. So it was said that whatever the petition has contended is invalid because of the act that was passed by the parliament. So the ruling of the Supreme Court in the second judge case becomes invalid because of the 99th Amendment Act of 2014. So this is what the Attorney General had to say in the argument between the center and the Supreme Court. The center also argued that act in no way is taking away the primacy of the judiciary, but in fact it is diluting the power of the executive, as only one member, that is the law minister, is going to be the member of the NJAC, as opposed to the 3 Supreme Court judges who are going to be the member of the National Judicial Appointment Commission. It also said that amendment, it was perfectly consonant with the basic structure as it is going to strengthen the independence of the judiciary. It's going to work as the check and balance and democracy. So the Solicitor General Ranjit Kumar, he further argued that collegium system is a failure, and it worked on a system of interdependence where there is no transparency. So one of the arguments against the collegium system is that it lacks transparency in its functioning. Right. So far we've understood what National Judicial Appointment Commission is. We've understood the collegium system, and we also discussed the 3 judges cases in which the collegium system was evolved. Right. So this is basically is the tussle that between the center and the Supreme Court over the appointment of the judges. Right. Now what happened in the year 2015 when the 5-judge bench of the top court, that is Supreme Court, while hearing the Advocate on Records Association case and their petition, it gave ruling with a 4-1 majority that NJAC was unconstitutional and violated. So basically there is one more argument which says that judges or the judiciary of India was judge in their own case. So NJAC was basically an appointment commission which was supposed to decide the appointment of the judges. However, in October 2014, the 5-judge bench case, it ruled that NJAC, which is National Judicial Appointment Commission, is unconstitutional. Right. So that this is one argument, that judiciary was judge in their own case. Now the bench also admitted that all was not well with the collegium system. So it was also agreed, or it was also accepted, that collegium system does need reform when it comes to the appointing the judges, so that the time was ripe to improve the system of judicial appointment. So that's it for today. Thank you so much for watching Tarun IAS. If you want to download the PDF of this session, you can go to the Telegram channel. The link will be given in the description below. Have a nice day.